Okay, you're here in the case of State of Florida versus Michael Morrison. We have counsel make their appearances on the record. We'll start first, please, with the state.
John Reed for the State Attorney's Office.
Defense.
Your Honor, good morning. Michael Ross for Mr. Michael John Morrison.
Okay.
Michael Morrison.
Good morning, sir. Okay, so thank you, Mr. Ross. Let the record reflect Mr. Morrison is with us here in open court as well. And we are here on, I think it's a motion to convert bond to simply ROR with pretrial services. Is that right?
Yes, Your Honor.
Mr. Ross, I had a chance to review the file somewhat yesterday.
If I may first just fill the court. Judge, I'm sorry for the delay. I apologize for the lateness. I had a break-in in my office. The Titusville police were there. They arrested a former employee of mine, a female, who was actually coming out the back door with monitors and computers. And I had to wait until the police let me go because I had a little statement. So I apologize for the delay.
I'm really sorry to hear that. Practicing law is stressful enough without having that, and particularly with a former employee. I can't imagine in any event. There's no problem. We had the 9:30 that was scheduled to start. We were able to take that earlier, and so it freed up a little time. So
As I was telling the court, this should not occur again. I apologize to the court.
okay, I understand.
If I may proceed forward.
Yes.
The court, you said, has read it. Is there anything the court wants me to give further information?
Yes, I do, and that is I reviewed the entire file. I had a chance to look at it. It's a pretty extensive file, as you know. I'm assuming you had to go back in and do pretty much what I did when I started looking at it. And I know that the pretty much the identical motion was argued before Judge Marriott, it looks like, in January of this year. So if you can tell me what's changed since then, why you refiled the motion, I think that's a good place to start.
Thank you, Judge. As the court knows, or should know, I've been practicing 30 years, and as I believe, when there's a change in judges, and especially when a court disqualifies themselves because either they don't believe they can be fair and impartial, or whatever the reason may be, and I wasn't given privy to the reason why Judge Marriott disqualified himself.
I wasn't either. All I saw was, as chief judge, I reassigned it, and we do a normal rotation. In the normal rotation, I was the next judge in line, so I just reassigned it to myself. That's how I got on it.
Yes, Your Honor. So as I said, I don't wish to presuppose what the reasons may be, but once one judge formally disqualifies themselves, it may have been that they were unable to sit without prejudice, but therefore I have a right to bring it again. So for that reason, I brought it again, believing the next court may use better fairness and impartiality to look at this matter and judge it appropriately. Additionally, Your Honor, nothing other than the fact that more time has gone by that continues to go in my client's favor to show that he's not involved in any criminal activity. He has no prior criminal activity. He's not fled. He's not running. He demands to pay for it. We don't want even a misdemeanor offer that the state has given, even as of today. We don't want anything but to go to trial. My client is trying to get me additional money to set the depositions that we're going to need. We're going to have a flurry of depositions, and I anticipate going to trial. This has injured my client by continuing to be on a monitor and having posted a bond as well. It's not like he's not on any monetary bond. So he's out on the bond, which guarantees his appearance, but additionally, he's got all of these other configurations. And he's been here to court every single time. Every time, no matter how many other attorneys were involved, Judge Marriott brought that out as a point that he had many other attorneys. Well, as you know, in the past, the buck stops here. You've heard that before. And I love going to trial. And I've been to trial many times with Judge Marriott. I don't remember you, Your Honor. If I've had any case with you, I don't recall. But so with all due respect again, my client asked the sign of the court take another look at it, that he lives here, he has his family ties here, he's owner of a house here, his money comes here, he's not moving from Daytona, he's always been here.
What are the other restrictions that you talked about?
Well, he's got the...
Obviously, no contact.
Right. He's also got the laboratory testing all the time, because there was an allegation, without all due respect, that he tested positive for cocaine. We believe that to be a false positive. He's retested many times to show he doesn't use cocaine, he doesn't use drugs. He's been continuously tested before and after. That's not a find any drugs in his house that they charged him with for any reason when they busted and shot him, Your Honor. And we believe that, and as I told the state said that I was threatening him, and I'll put it out this morning, that I said this is malicious prosecution. I don't believe that my client should even be prosecuted right now. Now, whether or not we prevail in the 1983 Act or not, I can't tell you, but my client stands here not only innocent until they prove guilty, but Judge, I don't believe they have a scintilla of evidence that would demonstrate my client is guilty of anything based upon the facts of the evidence in this case. And I stand very convicted and affirmed in this belief. And therefore, Judge, I think that holding him under these restrictions of drug monitoring and so forth, you have the ankle monitors.
No, I'm a big number of that. They have where I can't even have a beer at a friend of mine's birthday party. You know, I didn't do anything, and I just think that all that is quite excessive. Like I said, I live here, and I have no intention of going anywhere. Every single time they have a court date for me, I've been here. But the restrictions on that pretrial release is just, it's like as if I'm guilty without.
So he pays $40 every time he has to go for drug testing, Judge, which is a financial hardship. And does the court want us to answer that?
Yeah.
Thank you. Please answer the question. How often do you
Wait.
look at the court and tell the court how often do you go for drug testing?
It's random drug testing. When they random drug test me, because of that false positive on cocaine, as soon as they drug test me, I go right to a private laboratory, and that's where they charge me $40. So that the last time they told me it was a week later, I went right to the private place and had it drug tested. The first time it cost me $120. Now it's $40.
How often do you go for drug testing?
It's random, maybe once a month or so.
Okay. Right.
But still, on fixed income.
And Mr. Rush, just so you know, my understanding of the law is that you have 30 days in which to refile any motions after a judge recuses. And your motion that we're hearing today is timely filed. I think you filed it within 7 days of the recusal. So
Yes, sir.
I think it was time to file. Okay. What else?
Anything else that you want to talk
It's a hardship for me to do it every day. I'm on a pacemaker defibrillator. I have diabetes. Just the checking in thing every month is 4 times a month, as opposed to if I was on probation, it would only be 1 time a month. It's just the whole situation. It's never bothered me. I haven't minded coming to do it for 3.5 years. I've been on this pretrial intervention. But when they transferred me to a new counselor down there, that's when they came up with that false positive. I'm afraid they're going to look for a reason to violate me because, again, I haven't agreed to. They gave me a pretty good offer. If I was guilty, I'd have took that offer.
Okay. All right, Steve.
Is for pretrial services, is it usually 4 times a month?
Checking?
Yes.
Yeah. Usually they do it once a week.
Can you change that?
Sure.
Is
You
that-
change it to once. You can change it to every day. You know.
I mean, here's my concern. What Judge Barrett did here, this in January, like you say, they asked to have this same thing, the pretrial removed. My understanding, Judge Barrett removed the monetary bond. There was, I think, if I remember correctly, there was a $20,000 monetary bond. So he released that monetary bond and kept it with the pretrial services.
Right. That's correct.
There
Mr.
has-
Ross.
Yes, he did. That was over my objection. That wasn't what I wanted.
Right, so I mean, honestly, I don't feel that Maryland was planning to be prejudicial, and I think that really this should just more or less, I don't want to insult the judge shop to just move there and give us what he wanted, so let's try round 2. That being said,
Well, in fairness to Mr. Ross, I don't think he asked Judge Marriott to recuse. Judge Marriott, it appeared, I haven't talked to him, I have no idea why he did it. That's not my role.
and I don't mean to, and like I said, I'm not trying to
Right.
say this in a negative light to Mr. Ross or anything like that. Ms. Morrison has showed up consistently, but there was the one drug test. I know they say it's a false drug test, but I mean, most people say they are. So, I don't think that's necessarily true. I would be amenable. I think there needs to be some sort of pretrial services, but I'd be amenable to moving it to the month. I mean, I think that would be fair. With no monetary bond, it's serious offense. I mean, the allegations that the background was used to
back once a jury rendered a verdict, either which way, and therefore we're sure that you have a bail bondsman, and therefore he could just enjoy being out pending the resolution by a jury. But the judge, irrespective of what I want to decide to do something different. And of course, that's the providence of the court. I'm not here to judge the court, and I'm not here to suggest that Judge Merritt in any of the dealings that I've had with him has been anything but fair. However, as I would indicate to the court, I don't know this case. He did talk to me about all the other attorneys that my client had, and I said, but I'm the last one, and I'm going to be going to trial. He seemed to take some offense to that. Now, again, that's just judging his demeanor. I don't know that to be true. So the state says he thinks he's fair, Judge, I don't know. And so I bring it back to this court. I know it's unfair, is that so far it's taken a long period of time because of the myriad of attorneys, because of the situation. My client has been here over and over and over for 3.5 years. So showing that he's not running, he's not fleeing, he's not doing anything wrong, he's not failing to appear, there's been no bench warrants. This is the way in which we look at a bond. We don't look at the facts per se, but we look at whether or not he's a risk to society, a danger to society, a risk to fleeing. The court knows all these things. You didn't get gray hair for nothing, Judge. So same thing with me. I've been doing this 30 years. And this man who stands before this court deserves to be released ROR because of even the foundation of the evidence and what's going on in this matter. Judge, we asked that the court release an ROR now because the bond was vacated. And, you know, even if the court wants another bond, give them a $5,000 bond. They'll pay the $5,000 bond and no problems. And don't put him incarcerated with the bond. He'll go out and get a bond, give you the $5,000 bond, so you have assurance. It doesn't matter whether it's 5 or 2 or 10, but you know, if the court needs some assurance that way, that's fine. But thank you.
All right, thank you, Mr. Frost. Okay, I'm going to grant the motion to the extent that I'm going to reduce pretrial reporting to once a month. I'm going to keep you on random urine analysis. No, sir, no drugs, no alcohol. That's going to remain the same. Otherwise, in other respects, I guess I'm denying the ROR portion of your motion at this time. All right, let's turn to a different subject. You are on my pretrial next, I think, for April 12th. If I have that right, our April 12th will lead to an April 27th docket call for a May 2nd trial. I have you as the #1 case on that docket.
Judge, may I look at something?
Sure, go ahead.
Judge, I know the court has heard many different things about attorneys who are quite busy, and I am, but I also, with all due respect, am going on vacation to Ireland.
Oh, good for you.
And finally, I need it so bad I can begin to tell you.
Okay, let me give you the dates again.
Well, wait, let me just look and see. Okay, I'm leaving May 7th, and I'm returning on May 16th from Ireland.
May 7th is a Saturday, right?
Yes.
Okay, this is a May 2nd docket. I can give you, so it would be an April 28th docket sounding. Is that 8:30, Justine? I think it is 8:30, April 28th.
April 28th is 8:30.
Right, and a May 2nd docket.
I just, I don't know what the process is. Right now, I'm supposed to have a trial, certain and murder trial, put it in there at that month.
Okay.
That's what it is, want to give you guys up. And then we said that yesterday. It's an old case, too. It's a 2013 case.
Well, we'll figure out which one is older, and if this case is older, obviously this one is going to take priority for that. I will.
And I'm not trying to argue with that, I just want you to be aware, but it's a murder charge.
Right, I understand. But we'll leave that to us. I'll coordinate with Judge Marriott. You're not going to have to be in 2 places at once. Mr. Ross, you won't have to be in 2 places at once. So, but I had that time available to you, and I had this listed as my #1 case for trial that week. If you want it, I'll give it to you. If you want another date, I can give you May 11th for a docket sounding, and May 16th for a trial week.
Judge, I'll be returning on May 16th, so I don't want to...
That's probably not going to work for
It
you.
would not work, Your Honor.
All right, we want to do the April 28th and May 2nd then.
And how would that, if we start a trial, I don't anticipate we'd be done on the 7th.
Sure.
We start a trial on May 2nd.
how many days do you think this is going to be?
Judge, with all due respect, I'm a little bit verbose on trials over 30 years, and considering that the state has a numerous amount of witnesses, it depends upon what witnesses the state's going to call. So if they call as many as I anticipate, I would think it's going to go 4 to 5 days.
Do you think so?
I don't mean any disrespect to Ross, but I'd say a normal, like most attorneys, it might be a 2-day trial, and
Including jury selection?
oh, not, well, 2 days plus a jury selection.
Okay.
But that would be my guess, and again, I know Mr. Ross's trial is going to be a little longer, so that I can see it stretching to 54 days.
My problem, Judge, is that, God forbid, we get to a Friday night and the jury has not rendered a decision. Now, of course, I have other attorneys, I have 4 other attorneys, I can invite them to be here with me in the event that should occur. But on Saturday, I'm going to miss my flight with other people as well who joined us.
Judge, the other thing, I mean, to be honest, I mean, Mr. Ross, I know this, but I believe he wants to take quite a few depositions. And I just don't, if he's taking all those depositions, we'll get right to the complain about it, but I don't see that any possibility that he could take all those depositions by May 2nd, because I don't need my calendar. I mean, I'll do my best to accommodate it, but I'm supposed to be going to be doing the engagement trial next week.
Monday.
Yes, sir. And, I mean, like I said, I'll do my best to accommodate it. My schedule's fairly full, and if he's trying to take, I mean, I don't know how many depositions you want to take, but it's probably at least 20, right?
It's quite a lot, it's at least 20.
I mean, I just, realistically, I don't want to tell you, put this as a priority, and then we show up and say, we haven't finished half of it.
Well,
I mean, I think you're talking, I know the piece is getting old.
it's a 2012 case. It's the only 2012 case on my docket. I suspect it's the only 2012 case on your docket. So I want to get to it. Mr. Morrison is indicating that his pretrial services is a hardship for him. I think he's being genuine when he says that for reasons that have nothing to do with that. I don't want to change that, but I want to get this case to trial. I want to set it for a date that you can depend on. We're going to trial. He has every right to go to trial. I'm going to give him that right. And I don't want to, we don't need to dally around with it. Let's
Judge,
get
I'll
it
be
to
ready any
trial.
second, as long as the court, with all due respect, will advise the state that they need to be very liberal in setting up the depositions, so that I'm not going to have some delays in getting all the depots done, which is fine with me. And Judge, I don't want to delay this any more than it needs to either. So I'll bring another attorney. Should it go on beyond that Saturday, then another attorney will have to sit and wait for a opinion by the jury.
I mean, just, if I'm looking at this schedule, I mean, you know, I do what I can, but I have the Guzman trial with you, it's going to be a 2 or 3 week long trial. I have another week-long trial, so I have the Guzman trial and a week off, and another week-long trial and a week off, and another murder trial. They're all, I believe, will go, you know, some stuff can change. And, you know, that's it. You know, and those weeks, I'll tell you, my calendar is dotted with things that I'll do my best to accommodate them. And, you know, it's not this process fault, but I don't think it's the state's fault either. These depots haven't been done. This is, I don't know how many attorneys that there are, but if you want to get 40 depots, I don't think it's reasonable to say I have 2 weeks to accommodate 40 depots. I think that April.
We'll challenge that later. We're going to keep these dates. April 28th is the docket sounding. May 2nd is going to be the trial.
And what's on
Okay?
this?
The docket sounding is at 8:30.
Right, I got that.
The docket is 8:30.
Trial,
Okay.
8:30 on Saturday.
Right, May 2nd at 8:30.
So 5/2 is the trial date at 8:30.
Right.
Thank you, Judge, just want to make sure.
Right, and I'm going to mark this down as my #1 case for that docket. Now,
No problem.
I know you got other attorneys up there, so if you need to, do that. Let's start with, figure out who you actually are going to call up trial and let them know. Okay, so that they can narrow the list down from those that you may call at trial to those that you're going to call. Okay, let's figure, and Mr. Ross, you do the same. And let's get all of the discovery done that you need to get done, and let's move this case to trial.
Just-
I mean, I'm not trying to argue with them, I'm not trying to be disrespectful. I just asked for the different days, since I do have that murder trial as well, and, you know, it's gonna take a long, I mean, that's gonna take a long time to gear up. I mean, I just don't wanna waste wait till that Monday and then have us pick which trial, because both these are gonna take a tremendous amount of time to gear up. I'm already pulling witnesses into that May 2nd murder trial to, both that the week before, both with me with witness prep. That's why, I mean, would you consider doing this, in a June trial date? I just think it's more feasible that we.
Mr. Ross, you tell me, June 6th,
I
work better for you?
I cannot, Your Honor.
Okay,
I have
let's
a,
leave it set.
I have a murder trial that's been outstanding for a long time in Punta Gorda, and the judge had not knowingly and voluntarily disqualified himself before he took over that case. And then when we started to go to trial in Punta Gorda, that would take 3 weeks, the judge found out he disqualified himself, removed himself, and the judge came in and has now set me for the June 2nd date. It's on an old murder case that I've got to be.
I mean, I know we're getting further out there, but I just.
I'm not pushing it that far. Let's keep it on the date that we have.
Judge,
Do the scheduling as best you can.
I'll be
Thank
ready.
you. Now, let me ask you one other thing. I have this set for a pretrial on, I think it's April 12th now.
You do.
Okay, do we need a pretrial? I don't need one.
What was the date of the May 2nd one?
No.
April 28th
And 8:30.
at 8:30 is the docket sounding, May 2nd is the trial date.
And 8:30.
Yep. Do we need a pretrial?
I don't need a pretrial, Your Honor. The state has-
Let's go right to docket sounding.
That's no problem, Judge.
All right.
We're ready for trial on 5/2.
Sounds great. See you back here April 28th.
Thank you very much.
Good afternoon, Judge.
You too.
Thank you.
Thank you, Your Honor.
Thank
you.
Thank you.
Morris, Mr. Ross, I'm dealing.
Thank you, you too. Take care.